Judgment in the matter of SM Algeria versus Entry Clearance Officer, UK Visa Section.
This case is about a little girl whom I shall call Susanna. She was born in Algeria in 2010 and abandoned soon after her birth. When she was 3 months old, an Algerian court placed her in the legal guardianship of Mr. and Mrs. M under the Islamic Kafalah system, which is the nearest thing to adoption allowed by Islamic law. Mr. and Mrs. M are French nationals of Algerian ethnicity who had gone to Algeria for the purpose, but had been living in this country for some years. Mr. M works here as a chef and has the right of permanent residence here. In 2011, Mr. M returned to the United Kingdom to resume his employment, while Mrs. M stayed with Susanna in Algeria. In 2012, they applied on Susanna's behalf for her entry clearance to the United Kingdom as their adopted child. Under the European Union's Citizens Directive, certain family members of EU citizens exercising their rights of free movement are entitled to join them in the host country. These include a spouse and a, quote, direct descendant, end quote. It is accepted that lawfully adopted children count as direct descendants for this purpose. But Kafalah children are not recognised as lawfully adopted children in UK law. So the question is whether they are nevertheless to be considered as direct descendants under EU law. Susanna was refused entry clearance by the entry clearance officer and by the first-tier tribunal and by the Court of Appeal. The Court of Appeal held that member states were entitled to restrict the forms of adoption that they would recognise for this purpose. The UK government is particularly concerned that the careful restrictions on inter-country adoption, which are designed to protect the children involved, should not be circumvented. The Supreme Court has decided that it is not clear whether Susanna qualifies as a direct descendant under the directive. The term must have a Europe-wide autonomous meaning rather than one governed by the domestic law of each member state. The EU Commission has expressed the view that it extends to children in permanent guardianship. But the concerns about their welfare remain. As the answer is not clear, this court, as the final Court of Appeal, is obliged to refer the matter to the Court of Justice of the European Union. 3 questions are asked. 1. Is a child who is in the permanent legal guardianship of a union citizen or citizens under Kafalah or some equivalent arrangement provided for in the law of his or her country of origin, a direct descendant within the meaning of the directive? 2. Can other provisions in the directive be interpreted so as to deny entry to such children if they are the victims of exploitation, abuse, or trafficking, or are at risk of such? And 3, is a member state entitled to inquire, before recognising a child who is not the consanguineous descendant of the EU national as a direct descendant, into whether the procedures for placing the child into the guardianship or custody of that EU national were such as to give sufficient consideration to the best interests of the child? Apart from those issues which are referred to the Court of Justice, 2 other issues also arose in the appeal. First, if Susanna is not a direct descendant, is she nevertheless an, quote, other family member who, in the country from which she has come, is a dependent or member of the household of the union citizen, end quote. Such people are not automatically entitled to entry, but the member states are under a duty to facilitate their entry and have to justify refusing it. The upper tribunal held that Susanna was such an other family member and remitted the case for the Secretary of State to decide whether to facilitate her entry. The Court of Appeal held that she was not. The Supreme Court holds that If she is not a direct descendant, she is undoubtedly an other family member for this purpose. Secondly, after permission to appeal to the Supreme Court had been given, the upper tribunal held, in a case called Sala, that there was no right of appeal under domestic law to a tribunal against the refusal of entry clearance as an other family member. The issue was therefore raised at the first hearing before this court, which had to be adjourned for full argument. Before the case came back before us, the Court of Appeal held, in a case called Khan, that the upper tribunal had been wrong, and there was a right of appeal in these cases. The Supreme Court agrees that there is. However, the regulations have since been changed to reflect the result in Sala, and the upper tribunal, in a case called Banga, has referred the question of whether excluding appeals in such cases is compatible with the directive to the Court of Justice. The hearing was held last month, but we do not yet know the answer.